Myself, Dr. K. Vijay Suganti, Assistant Professor, Department of Accounting and Finance, Tirthangal Nadar College. Today, the first class of Corporate and Business Laws. Do you know why this subject is introduced to the commerce and management students? When we do the business, we must know the minimum rules and regulations and principles. That's why this subject was introduced in our syllabus. This subject is a very interesting subject. Only thing is you should have interest to learn. You can understand this subject easily with examples and case laws. Let's get into the subject business law. What is this law? As a social being, an individual is expected to observe a code of conduct or a set of rules. The set of rules are embodied in law. Law denotes rules and principles established by authority, whether in the form of legislation or self-imposed customs applicable to people. These are enforced by state to regulate behavior of individuals and groups to secure justice, peaceful living and social order. Let me explain what are the sources of law. What do you mean by sources? Sources indicates the origin. The sources of Indian laws can be classified into two categories: principal sources and secondary sources. The principal sources includes customs and customary laws, judicial decisions or precedents, statutes or legislation, and personal law. The secondary sources includes justice, equity and good conscience and English law. The first source of Indian law is customs. What do you mean by custom? Custom is the usual behavior or established usage of a community in a particular place or region. It is a set of actions that is voluntarily and uniformly followed. In olden days, customs, that is the rule of action that was regularly followed, became law. In ancient days, custom was the only source to administer justice. Precedent is another important source of law, which is also called judiciary law or case law or judge-made law. Precedent is a past action, especially a legal decision which may act as a guide or rule in future. Thus, precedents help to arrive at a decision in courts. How legislation becomes a source of Indian law. Legislation means making or setting law. In the practical sense, it includes making new law or modifying on existing law. Thus, legislation is about enacting laws, and exercise of enacting laws by Parliament is referred to as direct legislation. The last source of Indian laws is personal law. What is this personal law? Personal law is defined as a law that applies to a certain class or group of people or a particular person based on their religions, faith and culture. In India, everyone belongs to different caste, religion and have their own faith and belief. Their belief is decided by the sets of laws, and these laws are made by considering different customs followed by the religions. Indians are following these laws since the colonial period. Next, secondary sources of Indian law. Under secondary sources of Indian law, we have justice and equity. What is this justice? Justice is the ethical, philosophical idea that people are to be treated impartially, fairly, properly, and reasonably by the law. The quality of being fair or impartial, fairness, is called equity. England undoubtedly afforded a rich source of supply of legal principles. Students, you should know the classification of laws. In this presentation, you have the broad classification of laws. Law is classified into international law and national law. Again, the international law is divided into two categories, that is public international law and private international laws. Under the national law, we have again two divisions, that is public law and private law. The public law is divided into administrative law, criminal law and civil law. The criminal law, it is under the Indian Penal Code. The civil law includes law of contract and law of torts. Private law includes the Hindu law and Muslim law. Till now we have discussed about laws. Now we will move to business laws and Indian Contract Act. The terms business law and commercial law and mercantile law are synonymous. Business law deals with rights and obligations arising out of mercantile transactions among mercantile persons. Business law denotes the aggregate body of legal rules connected with trade, industry, and commerce. Business or mercantile laws includes law relating to contract, sale of goods, negotiable instruments, partnership, companies, insurance, carriage of goods, insolvency, Consumer Protection Act. However, the scope of mercantile law is ever widening due to increasing complexities of business world. Law of contract is the most important and basic part of mercantile law. Now we will move to the history of Indian Contract Act 1872. The law relating to contracts in India is contained in the Indian Contract Act 1872. The act came into force with effect from September 1, 1872. It is applicable to the whole of India. The Act, as enacted, originally had 266 sections